It is my distinct pleasure to introduce our luncheon speaker today. Judge Jed Rakoff is a senior judge of the United States District Court for the Southern District of New York and was first appointed to the bench of the Southern District in March of 1996. In his career, he has served as a federal prosecutor and a criminal defense lawyer. He's the author of at least 5 books, over 100 published articles, more than 500 speeches, most recently a speech at his alma mater, Harvard, and over 1,000 opinions. He is a longtime faculty at Columbia Law School. He is a former member of the governance board of the MacArthur Foundation on Initiative on Law and Neuroscience. He's a member of the American Academy of Arts and Sciences, the American Law Institute. He's a judicial fellow at the American College of Trial Lawyers. He is a member of was a member rather, of the National Research Council Committee on the development of the 3rd edition of the Reference Manual on Scientific Evidence. He's a member of the Committee on the review of the scientific approaches used in the FBI's investigation of the anthrax mailings. He's a member of the National Commission on Forensic Science. And most relevant to our topic for this lunch today, he was the co-chair of the National Academy of Sciences Committee on the Scientific Approaches to Understanding and Maximizing the Validity of Eyewitness Identification in Law Enforcement and the Courts, a report issued by the Academy last year. Would you all please join me in welcoming Judge Rakoff?
So I'm very grateful to Matt for that very nice introduction. Unfortunately, there are too many people in this audience who know me well, so they'll demand rebuttal time. I'm not only very honored, but frankly a little intimidated to be addressing this audience because this is a very expert audience. So many of you have such great knowledge of forensic science. I was listening to the tail end of the last panel, and like most judges, I understood about 2%. But I heard that those arguments at the end, which were pretty interesting. I heard the defense counsel's argument, that seemed to be right. I heard the prosecutor's argument, that seemed to be right. And I had forgotten to bring my coin, so I didn't know how to decide who was really right. I also want to say I'm particularly pleased to be here at Fordham because my wife Ann is executive director of the Fordham Law School Corporate Law Center. I was given the choice of having lunch with her in her office upstairs or here with you folks. I chose with you folks because I knew that was the less intimidating alternative. So I want to talk about eyewitness identification. I don't have to tell any of you here that it is often among the most important evidence in criminal cases, most particularly street crimes, but some other kinds of cases as well. Although this is a conference on forensic science, we're not talking here, the testimony itself is not expert testimony. These are everyday citizens, often with no motive to fabricate or exaggerate or lie whatsoever, who take the stand, who say they saw the crime, and then they're inevitably asked, do you see anywhere in this courtroom the person you saw commit that crime? And they point right. I'm pointing at Jerry Laporte just out of courtesy, but and that's very powerful evidence. And yet, and this is why it's relevant to this conference, we now know pretty much for certain that the eyewitness identification testimony is quite frequently wrong. Just to give you some statistics that you may be familiar with, of the 329 people that have now been exonerated by the Innocence Project as factually, actually innocent of the crimes, often very serious crimes, that they were convicted of, in 72% of those cases, there was inaccurate eyewitness identification. 72% of those cases, they were fingered as the person who committed the murder or the rape or whatever it was, and that was wrong. That's a huge percentage. It dwarfs all the other factors that the Innocence Project has enumerated as being factors in wrongful convictions. The University of Michigan has done a more general study of all the reported exonerations over the last 2 decades. It's a total exceeding now 1,200. Many of those cases did not involve eyewitness identification at all. They were, for example, white-collar cases don't usually involve eyewitness identification. But of that 1,200, over 30% involved false eyewitness identification testimony. So this is a very serious problem. What causes false identification testimony, and what can we do about it? Well, as Matt mentioned, a few years ago, the National Research Council of the National Academy of Science set up a committee to study and try to answer just those questions. It was a committee primarily composed of very distinguished scientists. There were, however, some police chiefs, some prosecutors, some defense counsel, some law professors, and they were desperate enough to have one judge, namely me. So under the Peter Principle, I was made co-chair. And for me, it was mostly a learning experience. But what I want to summarize is what they came up with. It's now been published. Here's the report, but you can also get it online. It's called Identifying the Culprit, Assessing Eyewitness Identification. Basically, the committee noted that there are 2 kinds of factors that lead to false identification testimony. One kind of factor we can't do much about other than be sensitive to its existence, and the other kind of factor we can do something about. So what are the first kinds of situations, factors that we can't do very much about? Well, of course, they are limitations on vision and limitations on memory. The science here is really quite hard and pretty much undisputed. There are obvious limitations on vision that you're all familiar with, how good your eyesight is. There's some that you're probably not so familiar with. For example, when you focus on something at an angle of as little as 10%, so instead of looking at it dead on, you're just 10% off to one side or another, the number of photons from that image that impinge on your retina goes down hugely. It makes a great difference in how good your perception of that image is. Something that may be sort of common sense, but now has been validated through many studies. When there's a crime of violence, you're usually distracted. You're looking at the gun. even if you're a bystander, rather than at the face of the perpetrator. So that makes a big difference. Obviously, the amount of time you have to see what's going on makes a big difference. Viewing conditions like lighting, like the distance between you and what you're witnessing makes a difference. Something that was not known, say, 50 years ago, but now has been well established, is a big difference is accounted for by how familiar you are with looking at the kind of thing you're looking at. And the most prominent indication of this is that people of one race are much better at identifying the faces of people of their same race as they are identifying the facial features of people of a different race. So whites are good at identifying white faces, not so good at identifying differences in black faces, and vice versa. This is not something that's hardwired. This is a function of experience. Recent studies have shown that in highly integrated neighborhoods, this problem largely disappears. But of course, in the United States today, there are very few highly integrated neighborhoods, so it is a very serious problem. Psychological factors like stress and fear also impact your perception. And there's sort of a double whammy here, because the fact that you're under stress will make you less good at observing what you think you're observing, but will make you more confident in the long term of what you think you're observing. I'll give you an example from my own experience. So my courthouse is quite close to Ground Zero, and on 9/11, my law clerks and I, until the courthouse was evacuated, were watching the events. And we saw people jumping out of the Twin Towers because the heat from the fire had become so intense that they would rather jump to their death than be burned alive. It is seared in my memory, and yet, when I, in preparation for this very conference, tried to think of the actual image that I saw, and I know I saw someone jumping, saw more than one person jumping out of the Twin Towers, and I had a particular image in my mind, and then I looked up, and it was the image that appeared on the front page of the New York Times the next day. And although there was no doubt that I saw these people jumping, the memory I have of it, which I would have sworn was the memory of what I saw at the time, was really the memory of what I saw in the New York Times the next day, because that was so more sharp, and I could contemplate it without feeling quite the same stress that I had felt at the time. So psychological factors can make a significant difference here. It has also been fairly well shown that most people tend to underrate all these visual problems, all these factors that affect their visual acuity. Yes, if they're not wearing their eyeglasses or something like that, they're aware of the problem. But other than that, they are relatively unconscious of these problems, and that translates into juries being often unconscious of these problems. I'll come back to that in a minute. There are also problems that, again, we cannot do that much about with memory. Most visual observations of strangers, and when I'm talking about eyewitness testimony, I'm limiting it to eyewitnesses who see strangers. If you see your mother committing a murder, you won't have too much difficulty identifying her, but though you may choose not to do so. But but when it's a stranger, the memory of it fades quite quickly. This has relevance for lineups and show-ups and things like that. Basically, your really pinpoint memory, assuming you had one even to begin with, will fade in about 3 hours, so that you'll have a much less specific memory. It varies from person to person. We all know people who are sort of good at visual memories, people are good at sound memories, and so forth. So there's a wide variation here, but on average about 3 hours. Long-term memories suffer from two problems. One is the one that I mentioned in connection with the World Trade Center. Your memories tend to be influenced by subsequent events and to merge with subsequent events. So there are a lot of studies that show that someone who sees a crime taking place and has a sort of generalized memory of the face they saw, and then picks someone out of a lineup a few hours later, by the time they get to trial a year or two later, their memory will be telling them unconsciously that it's the lineup face that they saw. So they will be remembering, they think, that, oh yes, I remember that mark on his nose, and I remember how his lips were, and all like that. What they're really remembering is the photo they saw at the lineup that had all those features, rather than the actual visual vision that they had at the time. But the two will have merged in their memory. They won't be lying. They will think that they saw the original image as it was in the lineup photograph. Secondly, there are a great many studies that show that people get more confident in their recollections over time, particularly when they're being asked to testify about them. The reasons for this are not totally clear. Some research think that is because the witness is sort of putting his or her ego on the line. But whatever the reason, the studies are consistent. When someone first sees a crime being committed and then is asked to pick someone out of a lineup, whether they say, yes, I'm sure it's number 3, or gee, I think it's number 3, but I'm not really sure, will be affected in part not by only what they saw, but by their personality. Some people are by nature more confident about their visual perception abilities than others. But all of them will be more confident when they get to trial. So the person who said, gee, I'm not totally sure, by trial will be saying, yes, I'm sure. The person who said, I'm sure, will be by trial saying, I'm absolutely sure. In either case, they will honestly express. None of this is a function of lying. This is a function of frailties, if you will, of the human psyche and the human memory. Now, all those factors, and there are a whole bunch of them, are things that we basically cannot change. I can take a little hope in the fact that so many people now have cell phone cameras, and therefore, in addition to their own memories, can often do instant videos and the like. But these problems with memory, these problems with visual acuity are largely beyond the capacity of us to change. There are, however, other factors that can easily be changed. And I'll just dwell on a few of them, chiefly in terms of lineups, because lineups are a very important part of this process. They're important not only at what occurs at court if the case goes to trial, but since most cases don't go to trial, they're very important in the decision of the police and the prosecutor to go forward because they are convinced they have the right guy. So the Most lineups these days are photo spreads. And that's a good thing because it's hard to get on a quick turnaround 7 people who more or less look enough alike that the suspect is not, glaringly different. But you can do it thanks to computers. You can generate photographs quite quickly, which have, each of which corresponds to the general description of the culprit by the witness, and so you have a reasonably fair photo spread lineup. Problems occur, though, first in how the lineup is conducted. It's well known and probably common sense that if, for example, the person administering the lineup says, which of these is the person you saw, they've already introduced an element that could lead to a false identification, because it may be none of the 7. But there's a lot of research. It's not as strong as the research on vision and memory, but it's reasonably strong, that people administering lineups will often say all the right things. Don't assume that the person who committed the crime or the person you saw is necessarily here. Look at these 7 and see if there's anything you can tell us. But through body language, we'll nevertheless send off signals as to the person who the policeman administering the lineup thinks is the correct choice. And that body language will convey itself to the witness and will lead to a false identification. Another kind of bias that, frankly, we don't know how to solve is bias in the way the photographs are presented. So classically, historically, the person administering the lineup, and when it was a photo spread, would lay out all 7 photos, and when there was a lineup involving human beings, there'd be 7 people all standing there, and the eyewitness would be told, now, it may not be any of these, but do any of these seem to you to be the person who committed the crime, or something like that? And what happens psychologically is the eyewitness looks over all 7 photographs and tends to pick the photograph that is closest to what he remembers about the perpetrator, as opposed to having an actual memory that corresponds to one of those photographs. Why he or she does this is, again, controversial, but there's very strong studies that indicate that that's what a great many people do. They, in effect, do a kind of comparison between the photos and say, this one is closer to what I remember than any of the others, as opposed to saying, yes, that is, I know that's the person. And so the studies that first showed this tendency suggested that a way to solve it was through sequential showing of photographs. So you would show one at a time. But in fact, that hasn't proved to be much better. One of the main things the committee I served on did was have our statisticians reanalyze the data from many of those follow-up studies. And what they found is that people are still doing the kind of comparison. For example, no one picks the first photo they are shown. even if it is the right guy, even if it is the person they remember, because they want to see the rest. And as they're going through it, they're doing sort of a mini comparison. Sometimes they will identify someone before they get to number 7, but it's the same kind of psychological trait going on. And our statisticians concluded that there was no statistically significant difference between the sequential and the simultaneous lineups, except that in the sequential, there are a lot fewer people picked, both correctly picked and incorrectly picked. It's a harder situation to make a pick from, and so there are fewer picks made, but the error rate is not significantly different. Now, of course, that's just one area where we can, to some extent, control what's going on. There are plenty of other areas where we can control it. What's said to the witness either after he or she makes the identification or such as the policeman says, well, you got the right one. That doesn't happen too often. What happens fairly frequently is the prosecutor who meets with the witness 6 months later, in effect, blurts out, well, you got the defendant or something like that, or you picked the defendant out correctly, or something along those lines that reinforces what in some cases is a false recollection. Most cases don't go to trial, but where they do go to trial, there's this, frankly, farce of the in-court identification. Look around this courtroom and see if you see anywhere in this entire courtroom the person you remember committing the crime. Well, I'm not going to identify the person at the back of the room. Oh, yes, there's defense counsel and defendant sitting there side by side. That's him. Although every judge has had the experience of having the defense counsel picked out. Those are problems. What can be done about all this? Well, with respect to the items that we can control, there's some at least very straightforward, simple remedies. They don't cure the whole problem, but they are helpful. One is to have a lineup administered blindly, that is to say, by someone who knows nothing about the case. Most lineups occur in the police precinct station. So it's quite easy to get someone who knows absolutely nothing about the case and have him or her administer the lineup, and that way there won't be any body language that impacts. A second thing is to videotape the lineup. This can often be done. A third thing is to document right then and there the level of confidence that the witness expresses. Again, some people are by nature going to express a higher level of confidence than other people, but all people will express a much higher level of confidence at trial. So it is very useful for the judge and jury to know what level of confidence was actually expressed at the time of the lineup as opposed to subsequently. Other things that can be done are to familiarize prosecutors, defense counsel, and judges to all these limitations and encourage maybe not a full-blown Daubert hearing, but a certain amount of pretrial inquiry into exactly what the conditions were when the identification was made, what the conditions were at the time of the lineup, and so forth. With respect to the factors we can't control, the vision and memory factors, The recommendation of the committee's report was that where possible, experts be called. They could be called by both sides or jointly by both sides or just by one side. Not to comment on the eyewitness identification itself in that case, but to comment on some of the variables that I've just gone over and others that affect eyewitness identification. This is called so-called foundation testimony. And it sensitizes, or at least the theory is that it would sensitize juries to the fact that this testimony is not quite necessarily as powerful as it may appear. You may ask, why not do that through judicial instructions? Well, in fact, the state of New Jersey does it through judicial instructions, but that has caused some problems of its own. First, the instructions, which are pattern instructions, don't necessarily dovetail with particular cases. Secondly, and more importantly, when a judge, in effect, says to a jury, here are all the problems with eyewitness identification, juries, at least according to the preliminary studies that have been done of New Jersey juries since this was introduced, tend to throw out all eyewitness identifications, good ones and bad ones. They, in effect, read the instruction, the fact that the judge gave them the instruction, as a veiled instruction. Don't pay any attention to that eyewitness identification. That's not what the judge is saying, but that's the message, apparently, that is getting across. So cognizant of those studies, which are admittedly preliminary studies, because Jersey has only had this for a couple of years now, the committee came out with a preference for expert testimony, which won't carry quite the same weight and which can be subject to cross-examination and so forth, but recognizing that in many situations that will not be economically or logistically available, in which case we think that jury instructions are better than nothing. I take a lot of hope, of optimism from something that happened this week. Some of you may have seen it in the New York Times. On Tuesday of this very week, the New York State Bar Association, the Innocence Project, and the District Attorneys Association of New York came out with a unanimous recommendation in favor of all the things that we recommend in this report. Blind administering of lineups, taking the level of confidence at the time, videotaping where possible, and so forth. And though I was, of course, tempted to sue them for copyright infringement, no, it was really, truly gratifying to see that effect. The broader point, though, is, I think, more troubling. Eyewitness testimony, I think, is particularly powerful testimony because it doesn't suffer from any of the problems that most testimony suffers from. All evidence, of course, is fallible in one respect or another. That's why we have in criminal cases such a high burden of proof. But if you have, for example, a cooperating co-defendant on the stand, his motive to lie, the various inducements that may color his testimony are all well understood by lay people serving on the jury, and they can easily at least recognize the problem. At the other extreme, expert testimony, such as was being discussed in the prior panels, is now increasingly subject to judicial gatekeeping, judicial scrutiny, and so there are some limits that are being placed on that testimony. Eyewitness identification testimony historically hasn't had any of those checks and balances. The witness who is a stranger seeing a crime almost never has any motive to lie, and the jury recognizes that. The person comes across correctly as an honest person, and when he or she says, I am sure it's the defendant who committed the crime, most jurors see no reason to question that. There is no or very little gatekeeping, although our report recommends a certain degree of gatekeeping, but this is historically at least not an area, even in recent decades, where judges have much involved themselves. It's lay testimony, precipient witness testimony, and and therefore there's no reason to limit it. There are a few Supreme Court and state court decisions where really extreme kinds of mistakes lead to suppression hearings, but those are relatively rare circumstances. There is, I think, a real serious problem here that eyewitness identification testimony, though it can be improved, such as with the steps my committee recommends on lineups and the like, is subject to things that we can't control, intractable problems relating to memory, to vision, and to psychology that are innate, and yet lead in a terrible number of cases to false identification testimony. I think the best we can do in this imperfect world is at least make juries aware of these problems so that they are at least sensitive to them. And that, of course, is not my job, it's yours. So thank you very much. I'd be happy to